All right, Mike, thank you very much. This is crazy, and I live in Westchester County. I know it very, very well. I used to be the county executive there, so I know the political landscape. Westchester is a 3-to-1 deep blue county. So they're cheering this on in places like Briarcliff, where Donald Trump has his golf course, or in places like Bedford, or Newcastle, which is Chappaqua. Who lives in Chappaqua? Oh, yeah, the Clintons. So, of course, politically, this is playing very well, not just in New York City, but in the county just north of that, in Westchester. So who knows, if any of this has to go to a court in Westchester, they're all Democratic judges, and they're elected. So it's likely that they'll do the political thing and make sure they stick it to Donald Trump. So we'll see. We'll see what plays out on Monday. Of course, that's the deadline. Donald Trump is appealing this. Will he get any relief? I don't know. But let's talk about the process with two lawyers, Dwane Cates, who is a criminal defense attorney, and Leo Jacobs, who is a bankruptcy attorney. And that's an interesting one because that could be something that Donald Trump might have to do. So, Dwane, let me start with you for a second. Obviously, this is playing out in the New York courts. Clearly, the Eighth Amendment, which says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. All of that has happened to Donald Trump. What recourse does he have in the federal courts as this is playing out right now in New York state courts?
Well, he can always ask for a stay of this judgment pending his appeal. He can also offer to put liens on all these properties, which are valued way more than the $450 million, and to secure the judgment and wait until the appeals court rules. I expect at some level the appellate court's going to overturn this. It just can't stand. It's ridiculous. There's no victims. There's no damages. It's pure political play.
Overturn the verdict or overturn the judgment?
Well, I think it can be both. To the Court of Appeal, they're going to take it to the Court of Appeals and try to overturn the judgment because it was just crazy. I mean, trying to say that Mar-a-Lago is worth $18 million, come on. There's empty lots in that area that are worth $100 million. So it was just ridiculous.
So, Leo, what do you think about the potential, if he doesn't come up with the cash or doesn't come up with a bond, and I don't know what underwriters would do business with Donald Trump in New York knowing that they're going to be a target next, but what happens, I mean, with regard to bankruptcy protection, what are his options?
Well, there's actually, first and foremost, thank you for having me on the show. Second, there are really two options. There's the second and last stop on the F train, and there's the last stop on the F train. The last stop on the F train is a Chapter 11 bankruptcy proceeding. There's both an involuntary and a voluntary way to do that. I'll get into that in just a moment. And then there is something called the CPLR 50-40 method. It's really a state court judicial proceeding that can oversee the stay of enforcement without an appeal and without a bond. Now, it may be the first time you're hearing this, maybe not, but that state court proceeding is really like a pause. So it allows a petitioner of any interest to go into state supreme, New York County in this specific sense, and to limit, condition, modify the enforcement of its judgment. Now, that proceeding doesn't go to the merits of the case. It goes to the procedure of the enforcement. So in the event Trump wants to take the ability to stay enforcement of that judgment without an appeal and without a bond, 5240 is the only way that he should do it. And if he's watching this, this would be one of the very, very easy and safe methods in order to accomplish that. Now, say, for example, he goes into court and it is denied. The court does not want to limit, condition, or modify the procedure with which the enforcement is to occur and enforcement is to occur thereafter. There's really two options. One is the voluntary way. He avails himself and his entities avail themselves of the Chapter 11 proceeding. And then there's the involuntary way, where there's one more creditor, because there are 10 creditors in order to file an involuntary bankruptcy, a third judgment holder who has no bona fide dispute and is owed that money. Say, for example, Latita James and then we have the $83 million judgment. There's a third judgment of, say, $10 million. They get together and they can file an involuntary bankruptcy petition to have Donald Trump become involuntarily bankrupt. Now, that puts into process and into play many, many other processes. But to answer your question in short, those are the real three processes that Donald Trump should be aware of, should take into account. And 5240, again, is really up at the top because it identifies a mechanism to make periodic payments without an appeal and without a bond that can really, really help him in this case. And he should really avail himself of that.
Dwane, what about the federal monitor, a former federal judge, Barbara Jones, that the court put on top of the Trump organization to oversee literally everything? They can't do anything without her sign-off, and she has to make herself available to the court and also give periodic updates to the court. So she's basically in charge of, she's the CEO of the Trump organization right now.
And she actually is. I mean, she doesn't make the decisions. They can make decisions, but they got to be run through her. They've got to clear everything with her. They've got to let her know, what they're doing, where they're doing it, why they're doing it. And it's basically just to make sure that he doesn't, divest himself of any of these assets and move them to where they can't get, the creditors can't get to them. And now that would be pretty hard to do with Donald Trump because everybody knows what he owns and where it's at and what's going on. And so, I don't think her job's going to be very hard.
Leo, we got like 30 seconds, but really quickly, a lot of these are in LLCs, these properties, right? How does that come into play against Donald Trump's judgment?
In short, you can't get to Donald Trump in the event that the membership interests, which are the membership interests that he holds in those LLCs, are going to get attacked. So it really separates himself. And the LLCs, to the extent that he owns any shares, will play in the enforcement proceedings that Letitia James has against him personally. So say, for example, LLC 1 is owned by Donald Trump 100%. They could put a lien on his fair share of the returns that are coming out of the LLC. So if he has $1 million coming out of the LLC on a W-2, she can technically speaking, or actually speaking, have the court enjoin him from taking those proceeds, and she could take it for herself. So that's one of the ways.
And she will, or she'll try. Leo
try.
Jacobs and Dwane Cates. Yes, she will. Dwane Cates, thanks, guys, for being with us tonight. Interesting stuff.
Thanks for having me on.
All right, more to come.